under Clause 8 can interfere with all the activities that are allowed for an agent of a foreign minister allows. It is an affront. And the bill assumes that what is offensive to the Constitution becomes lawful simply by allowing it under an act of parliament, insofar as they will infringe the sovereignty of the citizens of Uganda by subjecting it to the influence of foreigners. The so-called acts allowed under the proposed law will still be offensive by their nature, being an affront to sovereignty. The minority note, therefore, that the bill, had the bill been conceptualized properly, indeed by being overly vague and ambiguous in relation to its application and the activities it seeks to regulate, it may be declared void for vagueness and the stretching beyond the parameters of the Constitution. At page 9, the bill infringes several articles. My colleagues have mentioned quite a number, specifically Article 1. I also opine that it offends Article 259 to the extent that it seeks to amend the Constitution by infection. This was canvassed in Paul Semogere Zakalo Luma and Juliet Reina Kafire versus Attorney General, Constitutional Appeal number 1 of 2002, in which the Supreme Court declared Section 5 of the Constitutional Amendment Act 2000 as unconstitutional, since it had the effect of amending Article 28, Article 41(1), and Article 44(c). Right Honorable Speaker, in that case, it was declared unconstitutional for having been passed without following the procedure under Chapter 8 of our Constitution. Court also discussed the effect of Section 5 of the Constitutional Amendment Act, which proposed to introduce new clauses 2 and 3 of Article 97 with the intention of restricting citizens' unhampered access to information in the possession of the state. You may read for yourselves, and I'll proceed to page 12. The bill infringes on the following articles of the Constitution, making it grossly unconstitutional in form and effect. Number 1, unconstitutional deprivation of citizenship. Right Honorable Speaker, citizenship is not granted by statute. By seeking to reintroduce the foreign element against Ugandans, the bill offends Articles 9, 10, 11, 12, 13, 14, and 15 of the Constitution. Freedom of expression under attack. Article 29, 1A and B, which provide that every person shall have the right to freedom of speech and expression, freedom of thought, conscience and belief. Now clauses 5, 7, 8, 9, 7, 8, 10, 12, and 13, and the definitions of disruptive activities in Clause 1 directly criminalize expression and association, including influencing the public to oppose the policy of government. Clause 2(2)(g), engaging or participating in a riot or unlawful demonstration or assembly. The definition of disruptive activities is offensive, and publishing information said to weaken the economic system. Clause 13. These restrictions are neither demonstrably justifiable in a free and democratic society as provided for under Article 43(2)(c), which provides that public interest shall not permit any limitation of the enjoyment of the right and freedoms prescribed under the Constitution beyond what is acceptable and demonstrably justifiable in a free and democratic society. 3. Freedom of association and assembly threatened. Right Honorable Speaker and colleagues, Article 38(2) of the Constitution guarantees every citizen's right to participate in peaceful activities to influence the policies through civic organization. Now listen to this. Clause 7(3), Clause 8(3), Clause 8(4), and 12 substantially burden and in some places extinguish that right by criminalizing conduct that constitutes its core exercise. 4. Right of equality invaded. Under Article 21(1), all persons are equal. Now, when it comes to the definition of foreigner, Ugandan citizen residing outside, that has been sorted, and I accede to that. Then the foreigners in their own country, and converts persons into those, and those who deal with them. Intrusion of privacy, where the minister, the right to privacy of a person and property, and no person is subjected to unlawful search or unlawful entry into the premises. Clause 28 confers the person appointed by the minister to inspect the premises on an agent of a foreigner. Void for vagueness. I think the Honorable Betty Namboze has hinted on it, on the wide and arbitrary provision. Authorities to look at are Andrew Kalamaji versus Attorney General, Constitutional Petition number 5 of 2016, which struck down Section 25 of the Computer Misuse Act, Charles Onyango and another versus Attorney General, Constitutional Appeal number 2. The bill departs from the legality principle under Article 28. Interests of Uganda, I think Honorable Namboze has hinted on it, they are not defined. Agent of a foreigner, Clause 1. The definition is extraordinarily broad and captures any person who acts at the order, requests, under the direction, and control. I have specifically highlighted the threats that I consider legitimate in those bullet points at page 14. Now, the foreigner clause, I think, has also been canvassed together with disruptive activities and economic sabotage. At page 16, Right Honorable Speaker, I have highlighted the threat against the freedom from cruel, inhuman, and degrading treatment in the attendant authorities. The bill is accompanied with a defective on the following areas. 1, that the estimates of revenue and expenditure over the period of not less than 2 years after the coming into effect of the bill, when passed, the impact of the bill on the economy are not canvassed in the certificate. The certificate simply laid down the principle of what we may achieve in broad terms without telling us what we are likely to spend on implementing and whether government is prepared to spend that money. To that extent, the certificate is incurably defective and cannot support this bill. The bill has also the potential to destabilize Uganda's balance of payments. I think reference has been made to the submissions of the Governor Bank of Uganda, and I associate in the same terms. The financial sector and de-risking the operational paralysis, the capital requirements and the funding gap, the policy framework inconsistency and the voluntary shocks have all been canvassed. And then the second last is the amendments proposed by the committee, good as they sound, are equally excessive and disregard the precedents of the House. They also disregard the procedure that ought to have been adopted as elaborated by my colleagues earlier. Finally, Right Honorable Speaker, for my reasons, nobody will ask me whether he wrote it or not, because having said he's my brother, I think I know him better than anyone. The bill was rejected by the President and majority of the stakeholders in the committee that the committee engaged with. Right Honorable Speaker, the statistics have been given. Of all the persons that appeared, I think only 3 people supported, 3 stakeholders. The Honorable Yusuf Nsibambi, the Honorable Chiriowa Chiwanuka Attorney General, I treat him as a stakeholder because he was not the mover, and the gentleman from Fort Portal, Mr. Asimwe, that has been referred to. The President himself did state that this is not the bill that he initiated in Cabinet. But it does not stop there. Even General Severino Kahindo Tafire, who was stated to be the mover of the bill, evaded the committee proceedings, yet is the one who must have received the president's instructions, only to be misconstrued with immense respect by my son, General David Muhoozi, who appeared, and not the minister.
Honorable David Muhoozi is a son-in-law because he marries from him.
So yes, he's my son. In Africa, we don't say that. He's my son. The reason is that the minority, and that is me now, wish to remind colleagues that Uganda is here to stay, and therefore there is no need for firefighting. Target in the name and behind the curtain of sovereignty and security. The existing laws were not enacted in vain. They must be allowed to serve their purpose. The bill as proposed is inimical to democratic tenets, constitutional commands, and injurious to good conscience, which principles we must be jealously guarded and protected with utmost tenacity by all Ugandans of goodwill. The minority therefore recommend as follows. 1. The Protection of Sovereignty Bill 2026 that was read for the first time and referred to the Joint Committee on Wednesday, 15th April 2026, be rejected in its entirety for the reasons stated above. That the government undertakes to take practical steps to protect the sovereignty of the people from direct and indirect attacks, including by those claiming to fight for us. Medad Lubega Segona, MB Busiro East. I thank you.
Thank you, Honorable Medad, for that report. The opposition, yes, motion. There's a motion.
Right Honorable Speaker and Honorable colleagues, having heard from the substance of the majority report and the substance of the minority reports, I rise pursuant to Rule 17, Sub-Rule 1 of our Rules of Procedure, which states, a member may, with the consent of the Speaker, move that a rule be suspended in its application to a particular motion before the House. I therefore move, Right Honorable Speaker, that the application of Rule 214, Sub-Rule 14, and 214, Sub-Rule 15, be suspended to waive the requirement of a 3-day period between the presentation of a report on the bill and the debate. I beg to move.
Seconded. Okwalinga, Namilyango, Echweru, Balamu, Odoi, Kabanda, Honorable Acheni, Silas, Charity, Nekesa, Prakajara, Lanyo, Abe, Akelo, General, Esther, Sanoni, Apoloto, Abeja, Ibanda, Omara, Chut, Water, Mariamu, Eric, Gabriel, Toroma, Amuria, Phyllis, Nyakato, my brother from Bugisu, Maxi, by the whole side, and 3/4 of the other side, the vice president, the prime minister, the government chief whip, Honorable Yusuf Sibambi, the yellow boy, and then Mama Wabana, yellow girl, and then the Honorable Musinje, Honorable all the elders and all the disabilities. Honorable Nabakova is also there. Just 5.
Right Honorable Speaker, the justification of my motion are basically in threefold. One is that Rule 214 and Rule 215 are not falling under the confines of rules under Rule 17, Sub-Rule 4 that are entrenched, implying literally the two rules can be suspended. Reason number two is that this particular report on the bill was uploaded on our parliamentary information system. Members here present have perused through the report, and I believe with the turn-up you have in the House, we are ready to proceed just like we have proceeded with the main report and the minority reports. Reason number three is that the members in big numbers. Basing on the three reasons, I justify that my motion for suspension of the rule, if it pleases you,
of three grounds. One, it has been moved. Majority of the members are yet to access the records, the minutes of the committee meetings, and even the reports for them to internalize and appreciate the essence of this particular bill. Two,
how many members have reported to you that they have not had access to the information?
Right Honourable Speaker, speaking as the alternative Attorney General, we had 6 minority reports. Of course, you know the presentation has not been to its logical conclusion, and the majority of the people have remained seated here who did not stand up to support the motion have not had time to look at the reports, read them, internalize, and even the minutes. Incidentally, even the minutes of the committee were not read by the mover of the motion.
They are there.
So, three, most importantly, Right Honourable Speaker, this particular bill.
Right Honourable Speaker, I think the question has been put more to the members, because
I only want you to respond to what the shadow has said.
yes, the honourable member seems to doubt the members' capacity to read quickly, which I strongly oppose, because I think these members have the capacity to read and understand these things. So it's not. So, of course, this law is not about Ugandans; it's about agents of foreigners. So I think, Right Honourable, the question should be put to the members to decide whether they are ready to deal with the issues in the bill or not. I beg to submit.
Honourable members, I put a question that Rule 2014, Sub-Rule 14 and 15 be suspended to enable the House to deliberate upon the report of the Committee of Protection of Sovereignty Bill without having to wait for the 3 days as per the rules. Those in favor say and the contrary nay. The ayes have it. The ayes have it.
Honourable
members,
Speaker.
can you sit?
Honourable Speaker, the rules allow them to stand, and I wanted to quote for you the rule. Right, Honourable Speaker. Rule 107 of our rules of procedure provides for division. 1B. So a division may be ordered by the Speaker or Chairperson where B, the Speaker has announced the results of the voice voting, and immediately 40 or more members stand in their places, signifying their disapproval of the outcome of the vote. Honourable Speaker, from what we had, the noes had it. But you announced that the ayes have it. So these are more than 40 members who are standing up to say, put this to a division so that we count per head. It is the rules of procedure. Some of you don't read the rules. You need to start reading the rules. So, Madam Speaker, the rules allow for voting by division when 40 members stand up. These here are more than 40 members. So I would like to implore you that we do the casting by division so that we ascertain. Because as it stands now, we don't believe the announcement you made, Right Honorable Speaker.
Honorable members, I will not speak before you sit.
Madam Speaker, you have
You
to
sit.
kindly rule on
No.
the 40 members standing up.
Okay, you sit.
Right Honorable Speaker, the rule says you've got to first ascertain that these are 40 plus.
Honorable members, I don't need to ascertain. Even if you're 50, I am going to allow division. I am going to allow it, and then we see. And one thing I can tell you, whether we do what tactics of delay, we shall finish. Honorable members, Lope appoint a teller for the nays, and then Honorable Bua appoint for ayes. The ayes can move this side, and the nays move this side. Yes. Go to the lobby. Go to the lobby, and yes. Majegere. And the ones abstaining can remain with me here.